Thank you very much. Welcome to today's hearing. My name is Councillor Kelly, and I will be chairing the hearing, the summary review hearing of the Terrace Lounge, Bideford Avenue, Perivale, Greenford, UB6 7PP. My colleagues, Councillor Pravinanand and Councillor Sumner, we will comprise today's subcommittee. Hatun Zeb is the legal advisor to the subcommittee. Also present are Cornelia Harding, who is clerk to the subcommittee and will be minuting the meeting. Other Democratic Services officers may also be present as observers. In accordance with procedure, I will invite the police to present the application for a review and call upon any witness in respect of whom permission to appear has been given and answer any questions to put to them. Invite the premises to make their representations, answer any questions, invite the parties to briefly sum up their respective cases. At the end of the hearing, the subcommittee, accompanied by the legal advisor and the committee clerk, will retire to consider its decision. The decision will be given at the end of the meeting and confirmed in writing as soon as possible. The procedure is that when we deliberate, the panel and the clerk will stay in the room, and the legal advisor. You will leave the room and we'll give you an indication of what time to come back to the room for a decision. So you will have to sort of leave the meeting and come back. So just before I ask the police to introduce the application, could I just briefly go to the other members who I didn't mention? So we've got Mr. Panchal.
Yep. Yes, Chairman.
Could you introduce yourself?
Yeah, I'm Mr. Panchal, representing the client along with my legal advisor, Sarah Clover.
Sarah, Ms. Clover.
Yes, good morning, sir. Good morning to you and your colleagues. Sarah Clover, I'm the barrister who will be doing the presentation on behalf of the licensee.
Thank you very much. And police team.
Good morning, my name's Heather Oliver. I'm counsel instructed on behalf of the Metropolitan Police Service.
And we have police officers present.
Good morning, Chair. I'm Police Kerry Smart. I've submitted the application.
Thank you very much. I believe that's it. And Mr. Panchal, your client is with you as well.
Yeah.
Mr. Kuskel.
Can you put you on and say hello?
Yeah.
Good morning, everyone. My name is Kushal.
Thank you, sir. That's fine. Plenty of feedback there. Just bearing in mind that you're on devices quite close to each other. We may need to address that further down the line. And we also have Miss McLaughlin, I believe, from Ealing Council.
Good morning. Yeah, Mary McLaughlin from the Food and Workplace Safety Team at Ealing Council.
Okay, I believe that's everybody. So I'd like to, Miss Oliver, go ahead, please.
Thank you, sir. This is an application made for a summary review of the licence held by the Terrace Lounge in light of serious concerns held by the police regarding crime and disorder associated with the premises. Those concerns are such that the police are of the view that it is appropriate at this stage to suspend the licence held by the Terrace Lounge under the interim steps powers that you have. The licence holder and designated premises supervisor is Mr. Kushal, who attends. You have the licence itself at page 23 of your agenda pack. I say at this stage, I don't propose to call any witnesses, but as you've seen, PC Kerry Smart attends and can answer any questions that arise on behalf of you and your colleagues. If I can start just by briefly outlining the legal framework for today's application, and then I'll go on to address the factual basis for it. Section 53A, subsection 1, the Licensing Act, we say is satisfied, and that should be uncontroversial. This is a premises that is licensed for the sale of alcohol, and the relevant certificate has been provided by a superintendent and is at page 13 in your agenda pack. That certificate confirms that it is the opinion of the superintendent that these premises are associated with serious crime or serious disorder or both. And the question for the committee is whether it is necessary to take interim steps pending the full determination of the review. And the interim steps available to you are to modify the conditions of the licence, to exclude the sale of alcohol, to remove the DPS, if I can use the abbreviation, or to suspend the licence. You will no doubt be aware that guidance under the Act provides that the test for the kind of conduct that amounts to serious crime for these purposes constitutes an offence for which a person over the age of 21 of good character would be likely to receive a sentence of some 3 years or more imprisonment, or which involves violence. And in my submission, that is the territory that we are in. If I can outline the circumstances of the trigger event that has precipitated this application, the details are set out in writing in your packs, but to go through it in some detail. On the 25th of April, in the early hours of the 25th of April, at about 1 o'clock in the morning, a request was received by the London Ambulance Service to attend Venus Motors, which is actually at 59 Bideford Avenue. It's right next door to the premises. There was an unconscious 28-year-old male who appeared to have been assaulted. He was found to have life-changing or life-threatening injury. It was believed that he had been punched to the head or possibly hit his head on the floor. He was taken to hospital in the further early hours of the 25th at about 5 a.m. It was confirmed that he had a potentially fatal injury by a Dr. Darby at the hospital. He suffered a bleed to the brain. He was taken into theatre later that morning. In fact, he was returned to theatre the following day, all to manage the cranial pressure that he had suffered. I won't set out in details the surgery that he underwent and the injuries that he suffered or his prognosis, but you can see those set out in writing at page 15 of the agenda pack. We understand that he is currently stable in an induced coma. I can see that one of your colleagues is raising his hands. Can I address that question now?
Sure. Yes, go ahead.
I was just altering my light. I do beg your pardon.
I'm so sorry.
Yeah.
I'm so sorry. Of course, I'll address questions as they arise or
yeah, no, well,
the end.
typically, ma'am, we just let you present and then we'll come. You finish and then we'll ask some questions.
Thank you. In summary, then, it appears that the victim in question has been assaulted close to the Venus Motors. He was left lying in the street unresponsive, and ambulance and police were called. It seems clear from those details that this amounts to a serious crime in the region of grievous bodily harm or wounding, and therefore that trigger in the Act is satisfied. There is, moreover, a close association between what happened on the street outside these premises and what had happened in the evening preceding it. We know that the victim had left the Terrace lounge minutes before this assault took place. Best guess is that the assault took place at about 57 minutes past midnight. We see from the CCTV clips that have been provided that the victim left the premises at 00:53. He's seen on the stairs outside the premises, so minutes before the incident took place. Geographically, it took place in very close proximity to the premises. You'll see from the Google Maps that image that has been provided at page 21 of your bundles that the location of the garage is directly next door to the Terrace lounge, and in fact that can be seen on the CCTV as well. The cars seen to the left of the stairs on the CCTV locate you with the Venus Motors. We know that the victim had been in the premises from around 9:30 to 10:30. Witness accounts differ, but it appears that he arrived at the Terrace Lounge between 9:30 and 10:30. Police have been informed that the victim is an individual who attends the bar regularly. The police investigation is of course ongoing, but I can say this much in terms of what that investigation has revealed about how the victim came to be in the premises and the circumstances of his attendance. It appears that he was in the premises with a Mr. Jitesh Halai, who is understood either to be the business partner of the license holder, Mr. Kushal, or certainly he told investigating officers that he works at or manages the Terrace Lounge. Accounts as to how the victim came to be there differ slightly, either that a friend gave Mr. Halai the victim's number as the victim wanted to come to the Terrace Lounge and wasn't sure he was going to be allowed in, or alternatively that Mr. Halai had been asked to host a social evening at which the victim was in attendance. What is perhaps more clear is that Mr. Halai and the victim spent some time drinking together in the Terrace Lounge on the evening of the 24th of April. They appear to have drunk a bottle of Jägermeister and a bottle of vodka. Mr. Halai informed police that he didn't have any recall of events after about 11 p.m. because he was so heavily intoxicated. You then see Mr. Halai and the victim leaving the premises together, and certainly they appear to be very heavily intoxicated. If I can just address you as to the 4 clips of CCTV that have been provided, I hope that you and your colleagues have had the opportunity or will have the opportunity to view those. But in summary, the 4 clips are as follows. Firstly, an internal clip, which has the timestamp of 23:06. This shows a group of people in the foreground sitting around a table. There are various bottles and glassware and on the table. The victim of the later assault is the gentleman in a hooded jacket. He wears that consistently through the evening, so you can identify him from that. It has a stripe down the side and down the trousers. He is seen at that table, standing at that table in the first clip. He also appears to be smoking in that clip. The second clip is also an internal clip. It's timestamped 23:45, so sometime after that first clip. Again, still a number of people sat around that table, drinking from bottles and glassware that are apparent on the table. The third clip takes us outside the premises, and that is time-stamped on the 25th of April at 00:52. That is understood to show the victim and Mr. Halai leaving the premises. And as I say, both appear to be heavily intoxicated. The fourth clip it effectively shows the same material, but is taken from a different angle and shows the 2 gentlemen walking down the steps onto the street. The investigation has also had cause to speak to Mr. Kushal because there was a nexus between the victim and the premises. His account was as follows: that the premises was open for takeaway food only, and that it was not selling alcohol or shisha. He has said that the victim attended only to purchase food, that he entered the premises to pay for his food and then waited for his order downstairs outside the premises, where the staff served him his food without any issues. And so it will be apparent that that account appears to be clearly contradicted by what is seen on the CCTV clips, and indeed by the witness testimony of the victim's movements and Mr. Halai's movements during the evening. So if I can outline briefly the concerns that really result from that factual matrix in relation to these premises. Firstly, and self-evidently, there appears to be a failure to follow the relevant COVID regulations, insofar as Mr. Kushal has knowingly allowed a social event to take place inside the premises. We understand that he was present during the evening. That certainly is what he appears to have told police. The current regulations only allow for outside table service with the rule of 6. You have, just to make that clear, and I'm aware that Ms. McLaughlin attends, emails from Environmental Health which show that the premises was warned last week, and indeed in a letter of the 9th of April, that they are substantially enclosed within the meaning of the regulations, which means that they are not allowed to operate, to serve food and drink inside as they appear to have been doing. Secondly, we know that alcohol, or it certainly appears from the CCTV that alcohol was being provided to a number of people at the premises who were engaged in a social event. Alcohol has been consumed by the victim and his friends. Inferentially, that would have resulted in potentially a substantial financial gain for the premises in breach of those COVID regulations. But thirdly, and perhaps most importantly for the purposes of this application, a serious crime has occurred directly outside the premises very, very shortly after one of its patrons left, having become highly intoxicated while he was at the premises. It may be considered that if that alcohol had not been consumed, events would have been different that evening, and certainly witness testimony would not have been compromised by alcohol, as it appears to have been. So the real nub of the crime and disorder failure is to have allowed such a high level of intoxication to take place at the event that was being illicitly held at the premises. Fourthly, Mr. Kushal's explanation as to what happened that night gives rise to real concerns about his integrity as DPS. Having said that it was only open, the premises was only open for takeaway food, and that the victim only entered to pay for food, that appears to fly in the face of what is in fact seen, which is the victim being present at the premises for a relatively significant period of time, appearing to become intoxicated at those premises, and certainly not attending simply to pay for takeaway food. It's for all of those reasons that the police seek a suspension of this licence pending a full hearing in 28 days' time. Unless I can assist you further, that's my outline of the application.
Thank you very much, Miss Oliver. Did you want to call any witness? Obviously, you reserve the right later, but this is normally the time that we do it.
Absolutely. I don't think PC Kerry Smart can add to anything that I have said. It would simply be if you have questions over and above what I have informed you of, she is here to answer them if you need her to.
Okay, that's helpful. Thank you very much. Ms. Glover, questions to the applicant?
No, thank you, sir. It's Clover. My name is Sarah Clover, like 4-leaf.
I beg your pardon. Yeah, I can see that now. Yeah. Okay. So would you like to present your case then, Ms. Clover? I think that's where we're at now.
Yes, thank you, sir. I should make plain that I've got, as you now know, Mr. Kushal Shah and Mr. Jitesh Halai present and available to answer questions, but the intention is that I will do the substantive presentation myself on their behalf. And we've got some apples and pears going on here in relation to the summary review. You'll be familiar with what a summary review is, and Ms. Oliver's kindly outlined the legal principles, but it's essentially an emergency lockdown procedure. Excuse the phraseology, we're all a bit obsessed with lockdown, but it's a holding position in a situation where a common or garden review won't do, because something that the premises are doing, something that's going on at the premises that's associated with licensable activities, is of such immediate risk to the public that they need protecting from that as an immediate intervention pending a normal review. Now, that's not what's happening here. That the public are not being protected from and do not need protecting from a random attacker who punches people in the car park or near the car park. That's a sleight of hand, and what the police have done, and perhaps understandably, is to muddle up breaches, alleged breaches of COVID regulations, which I'll unpack in a moment, with the assault, and mix it all up together and say that's the licensee's fault. But we need to unpack that, because that's not actually how a summary review works. Now, that there are some transgressions here in terms of the COVID regulations, things like social distancing, for example, which I'll go through. And it wasn't ideal, to put it mildly, that Mr. Kushal Shah did not give an accurate account of how the victim had come to be there. But there's a reason for that, and it's got nothing to do with the assault. So as you can see, we need to get a very clear, logical route through what has occurred here, with a view to you deciding whether it is necessary, because that's the test, for you to impose a suspension of the license, i.e. licensable activities, with the sole purpose of protecting the public from serious crime and disorder, because that's the route. And if that isn't necessary to do, but Mr. Shah has done something else that's wrong, well, there are other remedies for that, and other ways of marking that transgressive behaviour, but it's not serious crime and serious disorder. So I'm trying to differentiate there. You also need, and this is one of the police duties when looking at review or summary review, is relating what has occurred back to previous behaviour by the licensee. Previous conduct is relevant. These premises have been fully compliant with lockdown throughout the totality of the time that the government has imposed COVID regulations upon us. So some premises have breached COVID regulations by opening during lockdown. I think there have been some allegations in relation to other premises in the vicinity of these premises. I think even to the extent that members of the public have made complaints about some premises. I think some shisha lounges being open or attempting to sell shisha on the street. I think the police have had to go around and investigate. These premises were behaving themselves. They weren't doing anything wrong. And that's important, because that gives you a slightly longer view as to the compliance and the requirements of this DPS and this licensee. It's been trading for some time on a license. It's had no reviews, no interventions, no warning letters. He hasn't come to attention previously for the running of his licensed premises and the licensable activities. And that ultimately is what the licensing regime is all about: compliant, licensed trading. And so we've had that. The premises opened on the 12th of April, as they were entitled to do. Now, there are two elements here. The first is takeaway. They're fully entitled to operate a takeaway. That's legal. It's not in breach of the regulations. Nobody argues about that. So they're open legitimately for takeaway purposes. So the question is whether that is what was going on this occasion, but they're certainly entitled to be open. The second point is whether they're entitled to be open for outdoor trading. Now, that's a grey area. And I say that advisedly, because that depends upon whether the terrace area is enclosed or substantially enclosed. Now, you've seen the correspondence backwards and forwards with your environmental health officer about that, Mary McLaughlin. That is not a point that has yet been resolved. Mr. Kushal Shah wrote back to Mary McLaughlin, and you've got the correspondence saying, we believe we are 50% open. And she wrote back and said, well, have you taken into account your windows and your doors? I think she's done a visit recently. It's the council's view that it's not 50% open. I would take a different view. And I think there are some photographs. I'm going to ask Mr. Panchal in a moment or two to, not now, but in a moment or two, to show photographs of the open area if you're not already familiar with it. But it's roofless, it's a terrace. And so it's a question of whether the sides are sufficiently open or not. Now, it's that element that decides whether it was legitimate to be doing outdoor sales of food and drink to people who were seated. In principle, Mr. Shah was of the opinion and under the impression that he was open air, he was entitled to do it. Now, the upshot of the conclusion with Mrs. McLaughlin, and I'll be corrected by her if I've got this wrong, was that it wasn't worth arguing about. Effectively, it wasn't worth doing anything about, because he's going to be able to open on the 17th of May anyway, stage 3. There'll be a legitimate service indoors and outdoors. And Mr. Shah, certainly now, if not before, had agreed that he would not do the outdoor service, the outdoor sales between now and 17th of May, because it's so close. And certainly that is an undertaking that he would give to you today. And it may well be, and this is my argument to you, that is a proportionate marker for what he has actually done wrong. Even if you take the view that he was opening for outdoor trade when he shouldn't have been, and bearing in mind that the argument's both ways on that, and the untruth that he told to the police about the takeaway element, whether it was takeaway or not, the correct marker for that behaviour is the inability to trade for the next 2 weeks, which hits him in his pocket. Now that's a marker for the right level of transgression. The reason he told the police when asked whether he was serving outdoors that he wasn't is because he thought he was going to get in trouble with the environmental health officer for the 50% rule, and he thought he might get a fine. Now, that's not ideal, and I'm not excusing it. He should have told the truth. However, there is still a big difference between that, again, putting it into context with the years of compliant behaviour. He's not a serial offender, this man. He has other premises as well. These are not the only premises that he runs. He's Mr. Panchal's client. Mr. Panchal knows him and has represented him before. So that this was a panicky thing to do. It was the wrong thing to do, to say to the police, but that doesn't indicate serious crime, serious disorder for which he should be suspended or ultimately revoked. We need to keep these things separate, so that the closure for the forthcoming 2 weeks would be an appropriate marker for that kind of thing. So the incident itself, what happened? Well, again, it's a combination of everything, because Mr. Jitash Halai, as you've heard, is the business partner. So he was at the premises that evening in that capacity. He got a call from the victim. I believe the victim's name is Jay, who'd just split up with his girlfriend. He was upset. He went to the premises, which is consistent with one of the accounts. The other account is inaccurate. It wasn't a planned event. It wasn't a social event. It wasn't a party. What you've got on the video is a combination of Jitash Halai and the victim, who were there together. They were drinking, but they weren't drinking anything from the premises. Mr. Shah had picked up some bottles of alcohol for Jitesh Halai on his way in. We've got a Tesco receipt for that alcohol, which again, Mr. Panchal has with him and he can show you, which he bought at around 10 o'clock that evening because Jitesh had asked him to give him the alcohol so he could sit with Jay and talk and bemoan about the girlfriend situation. So you've got those two. You've got some other people in the premises waiting for takeaway, which they're entitled to do, and some other people in the premises seated for outdoor query, but that was the reason they were there, outdoor service of food and alcohol. So you've essentially got three different types of attendees at the premises. The alcohol that Mr. Jitesh Halai and the victim Jay consumed was not bought from or served by the premises. And the evidence for that is the Tesco receipt. And they wouldn't have paid the additional premium for the alcohol from the premises because they'd got the cheaper alcohol, because this was a boys' one-to-one, a heartache talk, and they both got drunk. There's no question about that. They did both get drunk. And you can see them on the CCTV. All of that is absolutely clear. They walked down the stairs. Incidentally, nice to note it's good quality CCTV from lots of different angles. So you've got that evidence nice and clearly. They went over the road, and it appears what happened is that one or other of them leaned on somebody's car or sat on it or did something to this car that the owner of the car took exception to, and came over and punched the victim. Now, the nature of the incident, the nature of the injury is fairly classic stuff. If you've had any dealings with criminal cases or anything of that sort, it's called a contre coup. So you got the punch, particularly when someone's drunk, they go down like a tree. They smack the back of their head on something hard, usually the floor, the pavement, a curbstone, and the brain ricochets backwards and forwards inside the skull, and that's where you get the bleed from. And that's why you can get life-threatening injury, even death sometimes, from a single punch. It's not the punch that does it, it's the smack on the back of the head that does it, and that's why you get the pressure building up and so on and so forth. So it's a nasty, but it's a fairly classic type of injury, and that appears to be what's happened here. So it's not necessarily the result of a sustained attack. You've got an attacker who's cheesed off about something that the victim has done. It looks like it's something to do with his car. You got the punch, down he goes, and that was the outcome. Now, it's that has driven the police to the summary review, but that punch, that fall, that injury has got nothing to do with the premises. Even the element of getting drunk has got nothing to do with the premises, other than the coincidence that it happened to happen there. It could have happened in someone's home. It could have happened in different premises. You've got to be able to make the causal connection, the nexus, and Ms. Oliver used this word. You've got to be able to connect the serious crime, serious disorder to the licensable activities at the premises, and be able to say that because of the licensable activities at the premises, that crime occurred. Of course, in this case, that connection is broken. The attacker hadn't been to the premises. The attacker hadn't had anything to do with licensable activities. And essentially what you've got is two men who were walking home, and they could have been anywhere on that journey, anywhere on that route home when this occurred. Nobody at the premises knew anything about it. Mr. Shah didn't know anything about it. The DPS and licensee, he wasn't aware of it, and was informed later on that that is what had happened. So that's the causal nexus, that's the serious crime, serious disorder. And my learned friend attempts to bolster that by saying, well, the other elements of the RIPA, the Regulatory Investigatory Practices Act, was triggered, which is the definition of serious crime, serious disorder. The first serious crime, serious disorder is making money out of serious crime. Well, Mr. Shah wasn't making substantial financial gain out of serious crime. He wasn't making substantial financial gain out of somebody getting punched and going to hospital. The breach, if you will, of the 50% open air rule is not serious crime, serious disorder from which he was making money. And in actual fact, the substantial amount of any money that was made, which wasn't substantial in those terms anyway, I mean, everyone's scratching a living at the minute, never mind about substantial financial gain, is coming from the takeaway. And there's no argument that takeaways are anything other than legitimate. So what the police would have to do to make that argument out is split out where the money was coming from, give you some evidence as to how much, verify that it's substantial, and say it's coming from a serious crime. None of those things stack up. So I invite you to disregard that limb of the Ripper test. The third limb of the Ripper test is that people were congregating for a common purpose. And I don't even think my own friend made reference to that because it's so tangential. That was actually written up in the application, because that doesn't work either, because people coming together for a common purpose has to be the common purpose of committing a serious crime or disorder. And there's no evidence of that whatsoever. So I invite you to disregard those red herrings, those also rans, and focus your minds upon what we're really here for, which is the punch, the attack. So what you're actually dealing with in terms of transgressions by Mr. Shah, what you're really dealing with is, was he open in breach of the 50% rule or not? There's some social distancing issues that I can see on the CCTV. And the fact that he didn't tell the truth the first time to the police, for which he's sorry and he apologizes. And those three elements together are not of immediate risk to the public of serious crime and serious disorder. And that is your trigger for suspension. So the remedy for that in my submission to you is to take him up on his voluntary closure between now and the 17th of May. That's a punishment. Of course, licensing proceedings are not punitive, but it is a punishment to him. So I'm seeing one of the councillors talking. I'm not sure if I'm supposed to stop. No, okay. That's a marker for what he has actually done wrong, but that's a very different thing from suspending the premises license for the punch. I'm asking the committee not to suspend the premises license, because that starts to get us into some difficulty. If the premises license is suspended when it's not necessary to do so, and we then come up for the review in May, we've then got an interim step that has to be dealt with separately. If it's not dealt with separately and there's any confusion about that, then if there has to be an appeal thereafter and the interim step of suspension continues, then we've got some complications that take some real unraveling. So it isn't necessary in this case, because he's doing what the suspension would achieve anyway, which is to stay closed, and that will certainly occur up until the point of the next review. You've got the option of looking at further interim steps at the stage of the next review anyway. If he didn't comply with this voluntary closure, well, that's important information for you anyway, to look at his compliance, to look at his credibility and his integrity. It would be a very stupid thing to do indeed, to give you a voluntary closure today and then not comply with it, and then come up for review and be judged for that non-compliance. And that's very, very unlikely. But as I say, it would be a good evidential marker for you in any event. He is a good licensee. Mr. Panchal deals with him on a regular basis. He's got his other premises. He hasn't come to attention. That should be given to him in his credit. And I've indicated what a summary review is for, ultimately. It's to protect the public. And I'm finishing up now, but this is all about public protection. How does suspending this license now protect the public from the serious crime of somebody else punching the victim? There is no likelihood whatsoever of that being repeated. That's a one-off. It was a random attack. It occurred on that night for the specific circumstances. The repetition of it is inconceivable. And there's nothing about the premises that could give rise to that happening again. And that's the logical route that I ask you to take. The fact that something occurs in close proximity to premises is not the same as the premises being associated with it. That implies some kind of causal impact, and there isn't any. Final point then is the Section 182 guidance, Secretary of State Section 182 guidance, which invites you at all times to look at the cause or causes for what has occurred, and thereafter the steps that you would need to take to ensure that it didn't happen again. That's the bit that's missing in this case. That's the bit that the police haven't analysed accurately. And for that reason, I ask you to take Mr. Shah up on the voluntary closure, but not to impose an interim step of suspension. Thank you, unless I can help you. And obviously, as I say, both gentlemen are here, Mr. Halai and Mr. Shah, if you have particular questions for them. Thank you.
Just one question for clarification, Ms. Clover, thank you. The voluntary closure would be for takeaways and deliveries. So in a sense, would the venue be shut in totality? Is that what was being proposed?
I need to double check that with Mr. Kushal. I don't know what he's doing in the way of deliveries anyway, but it would certainly be for the purposes of anybody attending the premises. Can I just get some clarification on that from Mr. Kushal Shah and Mr. Panchal as to how that would work?
Yes, Sarah, I've just spoken to the client while you were presenting it. It will be a total closure till the next hearing. So there will be no deliveries, no sale. The premises will close as it was before when it was a lockdown.
Yeah, but no deliveries either. So there wouldn't be Uber drivers coming to collect food.
No, it will be totally closed.
Yeah, thank you. Sure, thank you, Ms. Clover. I think that establishes that. Miss Oliver, you have questions to the premise representation?
No, thank you.
Okay, well, bear with me. Councillors, Councillors Anand or Councillor Sumner, whoever would like to go first, if you've got any questions.
I have no questions, thank you, Chair.
Councillor Anand.
I have no questions, Chair.
Okay. Just sorry, Miss Glover, you couldn't lip read, but did you want to say something there, ma'am?
Yeah, I just reminded myself that I haven't asked Mr. Panchal to show you either the photographs of the open air terrace or the receipt from Tesco. He's got those on a screen sharing facility. So if you'd like to see those to confirm the things that I've said to you, perhaps now would be an opportunity to do that if you wish.
Yeah. Yes, if you can, Mr. Panchal, that would be useful. Thank you, sir.
Sorry, Chairman, I will need to ask the host to allow me to share the document. It is up to the host for this meeting.
Yes,
Yeah,
Mr. Panchal, let me look into that.
Okay.
I mean, if you've got do you actually have the receipt in front of you on your person as we speak?
I can print it out because it's on my computer.
Okay, well, fine.
If you, Chairman, if you trust me, I can then send it or scan it and send it, as you know.
No, just, yeah, no, I just wondered if you physically had it.
Mr. Panchal, can you try again? I think I've enabled you to screen share.
Okay, I'll screen share it now. Yes, I can.
Meanwhile,
I've had it on screen share now.
thank you. That's useful.
Can you see it?
Yes, I can. I can see it very clearly.
Yeah.
Yeah, it was probably bought just around the corner, Greenford Hoover building. Yeah. Thank you for that.
Shall I remove it now?
I no longer need to see it. No.
Okay, so shall I just get it off, Chairman? Are you
Yeah, please. Yeah, thank you.
Thank you very much.
Mr. Panchal, we wanted to look at the photographs of the terrace.
Yeah, I can do that. That's the photograph of the terrace, Chairman.
Thank you, Chair.
You happy with that?
Yeah, I mean, it doesn't appear to me, I don't see an open roof as such. I don't see the skyline. because there's some, what I would imagine to be some artificial flowers hanging down. This might be an opportunity to invite Mrs. McLaughlin to make comment and representations on the venue. You know, but if that's the only, yeah.
That's another picture. Can you be able to see the other picture now?
Yes, I can see the picture. Yeah, I can see some. Is that Perspex screen there?
No,
or
no.
is it glass?
Next slide, sir. It's open, everything open.
It's all open. There's no
All
perspex
open.
there. It's all open.
Sure. Okay.
Okay.
Thank you. Thank you very much for that. Miss McLaughlin, did you want to make some observations on the premises in respect to the operation?
Thank you, Chair. Yes, I can, of course. So I'll just kind of give you kind of some the most relevant and recent history of our interaction with the premises. So on the 9th of April 2021, Mr. Shah was advised by letter, which was addressed directly to Mr. Shah, as well as the trading address of Terrace Lounge, as well as email, that the provision of shisha, water pipes, electronic shisha, or any other equivalent, whether for payment or otherwise, remains prohibited until the 21st of June 2021 at the earliest. The correspondence also confirmed that any indoor premises or indoor part of the premises in which food or drink are provided for consumption on those premises must be closed, and that the business must not provide food or drink for consumption indoor on its premises. The definition of what constitutes an indoor area was provided, and guidance was provided, which included recommendations to provide signage and information to customers to make it clear that your business does not offer shisha. Advise all of your staff by written instruction that they are to prevent anyone using shisha on your premises, and that staff themselves are also not permitted to smoke shisha on the premises, and do not allow friends, family, or anyone to smoke shisha on the premises. On the 20th of April 2021, designated officers of the council attended the premises. At the time of the visit, there was customers noted in the premises consuming food and drink. Following that, I contacted Mr. Shah via telephone, advising that the premises is substantially enclosed and must be closed for consumption of food on the premises. On the 21st of April, I advised Mr. Shah via email that the premises defined as substantially enclosed, and therefore it is an offence for him to provide food or drink for consumption on the premises. On the 21st of April 2021, Mr. Shah informed the council via email that they have stopped serving food and drink on the premises. So for the purpose of the regulations, and this in terms of the smoke-free premises and enforcement regulations 2006, it specifically states in regards to enclosed and substantially enclosed. So for the purposes of section 2 of the Act, premises are enclosed if they have a ceiling or roof, and except for doors, windows and passageways, are wholly enclosed either permanently or temporarily. For the purposes of section 2 of the Act, premises are substantially enclosed if they have a ceiling or roof, but there is an opening in the walls, or an aggregate area of the opening in the walls, which is less than half of the area of the walls, including other structures that serve the purposes of walls and constitute the perimeters of the premises. So when determining the area of an opening, no account can be taken of openings in which doors, windows, or other fittings can be open or shut. A roof encloses any fixed or movable structures or device that is capable of covering all or part of the premises, and includes a retractable canvas awning. So the first picture that was shown there did have the roof, so would be considered substantially enclosed.
Thank you. Is that you finished, Mary? Sometimes it's difficult when I don't see you.
Oh, sorry. Yes, I have nothing further to add.
Yeah, I've just gone mute. Thank you. Something occurred to me. We have got CCTV footage of certain times. This isn't a question for you, Mary, specifically. It's just a question perhaps to Ms. Clover. We've got footage of a certain time, and we, like you said, Ms. Clover, you've got the two gentlemen consuming alcohol, you've got takeaways going on. But how about, do we have footage or CCTV footage of other times of the day to corroborate the fact that people were just coming and going for takeaway? That's something I'd like to explore.
Chair, I don't think we've got it present. I'm sure it could be obtained. That's the kind of thing you might be able to take a look at. We'll flag it up. We might be able to take a look at that at the full review. I don't know we'd be able to get it in time for you to look at today. May I come back, please, on some of the things Ms. McLaughlin has said, either through you or through questions to her?
Yeah, that's, you made a moment, then absolutely. But anybody else just wanted to have any questions to Ms. McLaughlin? Councillor Nance, Councillor Sumner?
Chair, not to Ms. McLaughlin, but I do have questions that I would like to address.
Okay.
When he's there. Thank you.
Yeah, no problem. Thank you very much, Ms. McLaughlin. Ms. Glover's got some questions for you. Thank you.
Well, through you, Chair, really, it was more sort of clarifications. Mrs. McLaughlin, if you'd like to disagree with me if I'm getting it wrong, but the original letter that went out that you described, advising about shisha and indoors and so forth, wasn't directed at the Terrace or Mr. Shah specifically. It was a general advisory letter to all the licensees who might be doing these things, to give them some guidance as to what they should or shouldn't be doing. There's been no question that Mr. Shah has actually been using shisha or offering shisha at any time in breach of the regulations. That's not an issue. The issue is the food and drink service, and is it indoors or outdoors? There's a question mark over roof, because the flowers would not be a roof or a ceiling in accordance with the definition in the regulations. That's one issue. And the other issue is the proportion of the walls, doors, windows that are openable or not openable. And I hope you think it's fair to say that Mr. Shah wrote back to the council's letter saying it's substantially enclosed, saying that he did not believe it was, and he'd been advised to the contrary. So there was a dispute about it. He then invited you to come and investigate, to come and visit the site, and you did. And I think that's only within the last few days. You've maintained your position that you do think it's still more than 50% enclosed, but the agreement was it's such a short space of time anyway, between now and the 17th of May, that, you know, what's the difference? He might as well stay closed in any event. So I'm hoping that that's a fair reflection of the position, but that Mr. Shah has come back to the council saying that there, as far as he's concerned, this is not agreed. It's a disputed area.
Thank you, Ms. Clover. So yes, in that letter dated the 9th of April 2021, it was addressed directly to Mr. Shah at the trading address of Terrace Lounge on 55 to 57 Bidford Avenue. It did specifically say in that letter, in addition, the regulations require that all premises close any indoor premises or indoor part of the premises in which food or drink are provided for consumption on those premises, and also to cease providing food or drink for consumption indoor on its premises. Our COVID stewards visited on the 20th of April and again confirmed that the premises was substantially enclosed, as there is actually a plastic sheet on that roof above the flowers. I recently visited on the 28th of April, so just Wednesday gone by, and I confirmed that again, the plastic sheeting was still on the roof above them flowers. So again, will be considered substantially enclosed.
But the point I was making in relation to the letter was it wasn't written to Mr. Shah alone because he was doing something wrong. It was general prospective advice given to lots of different licensees about what they should be doing. And it's not the flowers that are the problem, it's the plastic sheet that's the problem.
That's correct. It was sent to a number of businesses, as we do provide guidance and advice to food premises and commercial premises across the borough. And again, yes, as the plastic was covering the roof, it would then mean that the premises is substantially enclosed, as there's no openings.
Okay. Sorry, Mary, because we can't see you, it's difficult to know when you're finishing. Sarah?
Apologies, nothing further to add. Thank you.
That's right. Yeah. Okay. Ms. Glover, was that? Have you gone as far as you wish to with this part at the moment? Thank you very much. Okay, let me just find my checklist, because we've done a bit of EOV now and lost my place. Councillor Nan, who did you have questions to, sir? Councillor Nan? Okay, Councillor Nan seems to, yeah. Who did you have questions to, sir?
My question would go to Mr. Kaushal.
Okay, so to Ms. Glover, please.
Yes, okay. Firstly, can you confirm what time the victim actually attended the premises?
Yeah, I am going to ask either Mr. Shah or
can I have clarification on what time the victim attended the premises, please?
Yeah, I'm going to ask one of the gentlemen themselves, either Mr. Halai, who was with him, or Mr. Shah, if they can confirm that with some precision.
Hi, yes, Jitesh Halai.
Yeah, we can hear Mr. This is Mr. Halai, yes?
Yeah, yes, it is, yeah.
One moment, sir, just for clarification. So you just need to, you obviously have been mentioned, so we do know who you are, but you might just want to state your name and your relationship for the record. And preferably, we would like, I ask that you put your camera on as well, please. Thank you, that's perfect. Yeah.
Yes, yeah, I'm Jitesh Halai. So he attended.
And sorry, who are you? So
I'm a friend of the victim.
Okay, and do you have a relationship with the business as well?
Yeah, I'm like an investor for the business.
Okay, fine. But yeah, but you're not a licensed.
Not into day-to-day running.
Yeah, fine. Okay, thank you. That's useful. Thank you. Yeah. If you could answer, Praveen, maybe restate your question. Sorry.
Yes, could you just confirm what time yourself and the victim, did you both come together, and what time did you attend the premises?
So I was there from early on, from around say 6 p.m., 5 p.m. and he came around between 9:30, 10:30. I wasn't checking the time when he actually got there, but it was a lot later.
Can we confirm what time it was?
You'd have to check the CCTV when he actually arrived. I wasn't keeping a track of the actual time when he got there.
Okay. The receipt says that he bought the items suggested that it was bought, and on the premises at that time the receipt was shown to us. The receipt says 4 minutes past 10.
Yeah, we didn't. That got couldn't quite hear that again. Can you say that again, about the receipt, Praveen?
Yes, Chair. The receipt mentions a time of 22:04. Mr. Halai is suggesting that he doesn't know what time he came. It could have been 9:30 or 10:30. I just need to verify that the receipt corresponds to what is the version Ms. Clover has said, that these drinks were brought from outside.
It wasn't Jay, the victim, who bought the alcohol. It was I said it was Mr. Kushal Shah I'll be corrected if I'm wrong about that, but it wasn't Jay who bought the alcohol, so the receipt doesn't assist you in timing so far as the victim is concerned.
Okay, so the question here is that what was being suggested is that the if I could be corrected if I'm wrong, but what is being said is that the victim bought his drink and consumed it himself. The DPS had no control over what he was consuming. Am I correct?
No, what I said was that Mr. Jitesh Halai asked Mr. Kushal Shah to buy alcohol for Jitesh Halai. What Jitesh Halai then did with it is a matter for him, and you can ask him here.
So there was some duty. It's not that the victim bought his own drink and consumed it without any, the DPS was party to him supplying the drinks, whether he was paid for it or not.
No, that's my point, and Mr. Halai will assist if he's able to, but Kushal Shah was asked to buy alcohol for Jitesh Halai, his business partner, and it was bought at Tesco and handed over to Jitesh Halai. What Mr. Halai then did with it is a matter for him. And Mr. Shah, again, he's here, you can ask him. I don't know if he knew what Mr. Halai wanted it for or when he was going to use it or why. Jay is Jitesh Halai's friend, not Kushal Shah's friend. So okay, Mr. Shah is not responsible for handing the alcohol to the victim.
I think we're just going in circles here. The drink has been supplied by the DPS to his friend, who's allowed him to drink that drink on the premises. That's right.
Well, I'm confused with the he and the he and the he. Mr. Kushal Shah, the DPS, has bought alcohol from Tesco to give to his friend and business partner, Mr. Halai. That's got nothing to do with the license or the licensed premises.
And which was going to be consumed on the premises. So whether Mr. Kaushal received the money for it or not, he allowed those drinks to be drank on his premises.
Well, I think if we're using this as a licensable activity legal analysis, this is legally wrong. This has got nothing to do with the license. It wasn't supplied to members of the public through the license. Mr. Kushal Shah, Mr. Jitesh Halai can help me here as to what the agreement or the arrangement was, but this is no different from Kushal Shah picking up a leg of lamb or a packet of crisps from Tesco and handing it over to his friend because his friend asked him to pick it up on the way to work.
The duty of care, when there is a premises, which I can be corrected again, which doesn't have a license, is allows customers to bring their own drink and consume it. But whereas a licensed premises, whether those drinks are bought by the customer or is supplied by the DPS, the duty is respondent to the DPS to observe that the four objectives are abided to.
Well, there is no such thing as a duty of care. If you're looking for that in the Licensing Act or the Section 182 guidance, it doesn't exist. Everybody's got a general duty of care towards their fellow women and men, but that's not a concept in licensing.
Okay, so the prevention of crime and disorder and public harm is in the license objective.
Look, let's get. Right. No. Your question's very good, but let's, if you could just sort of phrase them as question, and we can interpret as a mean. But I think Miss Councillor Anand is asking for a timeline of who bought what and who it was given to and where it was drank. And then obviously it's us, that's what you're looking for, isn't it, Mr.
Thank you, Chair. Thank you for summarising that. Exactly right.
I'll make some legal submissions in due course, but perhaps for purposes of the timeline, Jitesh Halai or Mr. Shah could give you the clarification you're looking for. Timeline.
Yeah, I mean, just talking general terms, Mr. Halai, what happened? Who asked who to buy what, and who went and got it, who it was given to, where it was put, where it was consumed.
So I basically told Kushal to buy it even before I knew my friend was going to come, because I knew I was going to drink and not. So I don't use the lounge supply. So I called him to pick it up. Then he's gone Tesco's and he's grabbed it on his way to work.
And where did and Mr. the gentleman who's now injured, when did he turn up to?
Like I said, I didn't check the time exactly, but it was around about 10 o'clock.
And obviously, and he came, and he must have been after 10:30 because you didn't have the drink by then. So he came and drank the stuff you bought you had got from Tesco's. Is that correct?
Yeah, but if I mean, if the Tesco stuff wasn't there, it's not like he was waiting around for it. He would have ordered. You know what I mean?
Yeah. Okay, fine. And you drank it where? Where did you physically drink it?
We was in the lounge.
In the lounge. And you were just you two were on your own, and you weren't mixing with other guests.
No, I was, from what I recall, is we was just drinking it ourselves.
Yeah, yeah. And the other people that were there, the indication I've been given is that they were just coming and going for takeaway. Is that correct?
Yes, that's correct. Yeah.
Yeah. Okay, that's fine.
Yeah, I have one more question, please.
Thank you. Go ahead, Councillor Nand.
Okay. This is a question for Mr. Corshall, Ms. Clover, if possible. Do the sofas remain in situ where we're talking about the shisha area? Do the sofas stay where they are, or do they go? Are they moved when the business is closed?
No, they stay where they are.
Okay.
Okay. So because I noticed that they're soft furnishing, not weatherproofed, so there must be an enclosure to keep them protected.
Yes, sir. That's why you can see the.
You're having a lot of feedback.
Yeah, Mr. Kutcher, you're going to have to, whoever is nearby will have to.
If you switch off.
Sorry, Chairman, I'm going to be asking Mr. Kushal to be speaking onto my speaker. So stay there. You can speak.
Yeah. Okay.
You can come behind me and speak. So he's here behind me, and I've got my mask on. So
we can just slightly across, Mr. Kushal. We want to see.
Thank you, Brush.
Yeah, thank you. Thank you very much.
Yes, sir. That's why there are the plastic perspex which is rolled up on to the level of the roof. So when we go home, we just put the plastic sheets down so the rain water doesn't come inside.
Okay, thank you very much. That's all we need to know carefully.
Chair, can I ask a couple of questions arising from that?
You can. Just give me a moment. I just want Ms. Zed, did you want to explore something in terms of Councillor Nand's line of question?
Nothing at the moment.
Thank you. Yeah, okay. Go ahead, Ms. Oliver. Thank you.
I'm just concerned that there may be a misapprehension here. My understanding of Ms. Clover's submissions was that there was an acceptance that there was food and drink being consumed on the tables in the terrace during this evening. Perhaps the alcohol that was consumed by the victim had been bought in from Tesco separately, but my understanding was that food and drink was being served and consumed on the other tables. And indeed, that is consistent with what we see in the CCTV, which is groups of people being present at those tables for a substantial period of time. And also what Mr. Halai has just said, which is that if the victim hadn't been drinking the alcohol from Tesco, he would simply have ordered some of the alcohol that was being provided by the Terrace Lounge. So I'm just concerned that it might not be quite right that the other people that we see on the CCTV were just there waiting for their takeaway food. I don't think that's correct. Can I just ask for some clarification on that?
Miss Clover, sorry.
Yes, so that is correct. There's, as I said before, there were three groups of people, three types of people present: Mr. Jitesh Halai and Jay, who were drinking the Tesco alcohol privately. Just they were a group. You got the predominant presence with people waiting for their takeaway, and they may have been sitting down waiting for their takeaway. I'm going to take it away. And then I think it was one table, Mr. Shah will correct me, but I think it was one table who were consuming food and drink supplied by the premises, and whether that was right or wrong turns on this issue of whether it was substantially enclosed or not, and you've heard the arguments about that. I take issue with Mr. Oliver's logical conclusion that had the victim not been drinking the Tesco alcohol, he would have been drinking alcohol supplied by the premises. That's speculation. It's a jump too far. The very reason why they weren't buying the alcohol from the premises is because they didn't want to spend the money on it. So that it's equally logical to conclude that they wouldn't have bought alcohol from the premises, and they might have gone somewhere else or gone back home past Tesco's to get alcohol on the way to talk somewhere else. The purpose of the exercise was talking.
Well, with respect, I'm simply quoting what Mr. Halai said, which is, and I wrote down the words, he would have ordered. And can I also make this point, that it is not the case that the victim and Mr. Halai are sitting privately. They are clearly, and this can be seen on the CCTV clips, interacting with a much larger group of people on a table covered with glasses and bottles. Can I just mention one other point about the CCTV, which has been raised? I think, Sir, you raised it in relation to what CCTV is available. We are limited to the 4 clips that have been provided by Mr. Shah. So those are the only clips that were provided to PC Smart, and that's what's been provided to the subcommittee.
So that's unfair, because if the police had wanted any other CCTV, they were perfectly at liberty to ask for it and it would have been provided. So that they can have any CCTV they want and they only have to ask.
Okay. Unless the police wanted to comment on that, but okay. Bear with me, please, panel. I think we can go to summing up now. So I'm just trying to, who goes last? I believe the applicant goes last. So that would be down to Miss Glover to go now. It's my understanding.
Well, I'm not going to take an issue with it, sir, but actually, typically, it's the underdog that goes last. It's the one that stands to lose.
Okay.
Which would be the,
that's fine. Let me, Hattie, would you like to just, what's your preference? What would you think is more robust in the process?
Councillor Kelly, it would be the police that would be closing in the first instance, followed by the premises licence holder represented. Thank you.
So we'll do it that way then. Heather, if you've got more questions, if you'd like to sum up, please.
Thank you, sir. Well, you have, from my opening submissions, the 4 principal concerns that were which this incident gave rise to. But if I can just say this, it is rarely the case that a premises is directly behind an assault. A premises can't assault somebody. An assault may not even have happened on the premises themselves. That's not unusual in summary review processes of this nature. The public can still be in need of protection from a premises that is being poorly run and giving scant regard to its obligations under the licensing objectives. The question is whether the premises are associated with serious crime. In this case, it was the failings of the DPS and the failings of the premises which precipitated circumstances which gave rise to the serious crime that I've outlined, where the DPS bought in substantial amounts of alcohol, allowed it to be consumed by his business partner or investor with another individual on the premises, resulting in a significant degree of intoxication on the part of those 2 individuals. And putting everything that you've heard together, it appears he knew he ought not to have been opening in the way that he was. He was on notice from the environmental health team that he should not be serving food and alcohol to be consumed on the terrace, and in fact had told, apparently misleadingly, Miss McLaughlin that he would not be serving food and alcohol on the terrace, but in fact continued to do so. And so all the things you've heard in my submission give rise to very real concerns about his adequacy as a designated premises supervisor. And my learned friend really made out the causal connection she questions herself when she said it is because somebody is intoxicated that gives rise in single punch cases to such serious potential consequences. Her phrase, they go down like a tree. Well, if one follows her logic through, it's because the victim had consumed so much alcohol on the premises, knowing within the knowledge of the designated premises supervisor, that he was so susceptible to serious injury as a result of the punch that happened on the forecourt of a garage just outside the premises. It is, with respect, semantics to divorce these premises from what happened afterwards. It's clear that the victim and Mr. Halai were drinking for a substantial period of time on the premises before this unfortunate incident took place outside. And in my submission, that is adequate for you to be satisfied that the premises are associated with serious crime. Some mention has been made of other ways in which the definition of serious crime might be made out. Just for the avoidance of doubt, serious conduct that amounts to serious crime is conduct that constitutes an offence for which a person who is 21 years or over with no previous convictions would reasonably expect to be sentenced to imprisonment for 3 years or more. Well, that would clearly be the case here in an apparent case of grievous bodily harm, or involves the use of violence. Again, that is clearly made out here. So in my submission, you don't need to trouble yourself with that aspect of the test. The question for you is really whether these are premises which are associated with serious crime and what you should do about it. And it appears to me that what is being offered to you is in effect that the license should be suspended until the further review. I think there was some difference between what Mr. Panchal said and what Ms. Clover said in relation to when that ceasing of licensable activity should last until, I think Ms. Clover said 17th of May and Mr. Panchal said till the next hearing. But in any event, the practical effect of that, you may feel, is better achieved by suspending this license until the further hearing and protecting the public in that way, unless I can assist you further.
Thank you kindly. Ms. Clover?
Yes, thank you, sir. I'm not going to repeat anything that I said previously. I've got 3 key points which focus predominantly on what my learned friend has just said. She said, well, assaults are rarely the responsibility of the premises because premises can't assault anyone. What usually happens in a summary review when there's been an assault is the premises have got it wrong in some key respect. They've allowed an attacker to get drunk, and the drunk attacker then picks on somebody in their drunken state, or the security staff throw people out on the street without taking proper control of them, and then there's a fight in the street, or the security staff are absent when they should have been present when something goes wrong. And you can get that very clear line of connection between what has happened and the licensable activities that have gone on and the way in which they've been managed. That's utterly absent from this case. And when my learned friend says, well, I've made out the connection myself because of the nature of the injury, that's even more apples and pears. The illogicality goes on, because the drunken state of the victim didn't cause the attack, it caused the injury. The injury is not serious crime. It's the person who delivers the punch that is the serious crime, and it would be a serious crime regardless of the nature of the injury. You don't go around punching people to the ground because they're sitting on your car. But the fact that the attacker did it is not because of the level or the nature of the intoxication of the individual. It could have happened under any circumstances. It could have happened because this person who thinks it's fit to punch people took a dislike to these individuals. The logic isn't there, the connection isn't there. Malone Friends said something about poorly run premises. These aren't poorly run premises. This has got nothing to do with the quality of the service that customers are receiving at the premises, or anything about their safety in the premises, or anything about security, or anything about anything. These are not poorly run premises. None of Mr. Shah's premises are poorly run. They're quality premises. The issue about whether he should or should not have been open is a matter of dispute. You may well reach your own conclusion about it today, be that as it may, but it's not serious crime and disorder. It's vital to separate these things. The 50% rule, should he have been serving alcohol or food or not, is amply met by the voluntary disclosure. He wouldn't have been closed, he wouldn't have needed to be closed if he had acceded to the 50% rule. He would still have been entitled to open for takeaway. There would still have been nothing to say that Jay, the victim, could not have consumed his own alcohol, gone to collect takeaway, walked away with it, leant on the car and got punched anyway. It's got nothing to do with whether the premises were open or not. And the final point is this business of duty of care. I'm alarmed with a term like that as if it has legal meaning in the licensing regime. It doesn't. There's no particular thing called duty of care that arises in the Licensing Act or the Section 182 guidance. Everybody has a duty of care to everybody. You can describe the licensee or the DPS's requirement to observe the licensing objectives as a duty of care, or observation of the law, or upholding the objectives. It doesn't matter. They are under a requirement to do that for sure. But that's a very different thing from Mr. Shah being asked to pick up some alcohol from Tesco on his way in because his business partner has asked him to do so. Now, that was at a time prior to the victim arriving at the premises for sure, that he was asked. The receipt gives you the time that it was purchased. It appears that the victim may already have been at the premises by the time Mr. Shah was purchasing the alcohol from Tesco. Mr. Shah had no knowledge. There's no evidence of any knowledge that Jay had arrived at the premises, had called Mr. Halai. Jay is Mr. Halai's friend, not Mr. Shah's friend. So Mr. Shah's involvement in this was to pick up the bag of alcohol, turn up to his premises and hand it over to his friend and business partner as he had been requested to do. And there's nothing wrong with that at all. There's no requirement to say, what are you going to do with it? When are you going to drink it? Who are you going to give it to? There is no duty of care on him to do that. There's nothing per se to prevent Mr. Halai from consuming the alcohol that he owns or giving it to his friend. These are not the things that Mr. Shah has done wrong or that have caused the attack later on. And again, it's very important to separate these things out. I'm not sure if it was being suggested that it's not permitted to bring your own bottle when premises have a license. The licensable activity is supplying alcohol to a member of the public. Mr. Shah did not do that. It's not part and parcel of the trading of the premises. We have to keep those things separate as well. So those are the points that I wished to make in closing. Unless I get any further instructions, that's what I would like to say. Thank you.
Thank you very much, everybody. I think that's it now, unless anybody would like to make, obviously there's no sort of right to reply.
Forgive me for interrupting. May I just say, from a timing point of view, I need to pick up my child from school between 1 o'clock and 1:45. If you're still decision making, I won't be able to come back in that space of time.
Fine. Well, what I'm just going to give Miss McLaughlin in a moment an opportunity to make any remarks. Obviously, as a representative, and then that will take us, say, to 12:05. So we will sort of throw you out of the room 15:15. I would expect it will take 45 minutes. So it probably we would likely to be coming back at 1 o'clock, but that would be to say the decision. So obviously you may not be around for that. I don't think we could do it any sooner.
I'll certainly be here if I can. Perhaps I can discuss this with Mr. Panchal as to whether he could cover for me if it falls in the period when I have to pick my child up.
Okay, Miss McLaughlin.
Thank you, Chair. So yeah, I'd just like to include that the Food and Workplace Safety Team at Ealing Council is the relevant enforcing authority under the Health and Safety at Work Act in 1974 in the Licensing Authorities area, and therefore a responsible authority for the Borough under Licensing Act 2003. And we have given Mr. Sharp clear warnings, advice and information that clearly set out the legislation and that the activities that he carried out or is allowed to be carried out at his premises compromise the public safety licensing objective and are breaches of COVID restrictions legislation. Therefore, we are also of the same view of the police that due to this failure to promote the licensing objectives and failure to comply with COVID restrictions legislation, the suspension of the premises license at the summary review hearing is necessary and the only interim step that should be taken by licensing committee that will sufficiently protect and uphold the licensing objectives until a further determination is made at a subsequent full review hearing. I have nothing further to add. Thank you.
And is there any fairness, Flavor, that I give you a moment to reply to some of those points?
Yeah, just very, very briefly, sir. Again, got to be super careful. It sounds like Ms. McLaughlin is inviting you to impose a suspension for breach of the COVID regulations. You can't do that. You're here on a summary review. The suspension is for serious crime, serious disorder. I don't think she's suggesting for 1 minute that the 50% rule is serious crime, serious disorder. That is something you can take into account at the full review. It should not buy into your decision at this point in time. Thank you.
Thank you. Hattie, just before is there anything you want to, and are we ready to retire? Seb?
Yes, I think Ms. Clover's made her closing speech. So
right.
Yeah.
I just want to be careful. We've included everybody we ought to. Okay, thank you very much. I mean, I made the time now 4 minutes past. 4 minutes past. I would anticipate that we will be back at 12:45. So you can, we will see you then. I also reserve the right to take longer should we need to. So our clerk Cornelia will sort of take people out of the room now, and then you'll be able to come back in the room at about 12:40. The room will be reopened.